Let's continue our meeting. Please invite candidate Zaitsev Oleksii Volodymyrovych into the room.
Доброго дня. Сідайте.
Good afternoon. Good afternoon. We are considering the issue of compliance of the candidate position of the judge of the Hague, Zaitsev Oleksii Volodymyrovych, with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the Anti-Corruption Court. Here we have present members of the PCA: Robert Heinbruch-Heisen, Chair Norman Ost remotely, Mary Kate Butler remotely, Gabriela Yotka-Gradskiena, John J. O'Sullivan, and Jessica Thompson. Members of the HQCJ of Ukraine: Mikhailo Bogonis, Людмила Volkova, Віталій Гацелюк, Ярослав Дух, Роман Кадисюк, Надія Кобецька, Олег Колюш, Ігор Коршнір, Руслан Мельник, Олексій Омелян, Андрій Пасічник, Галина Шевчук. You have the right to request recusals, submit motions upon permission of the chair to challenge decisions, express your positions. Do you have any recusal requests? I have no recusal requests. Thank you. The co-rapporteur is Kolyush Oleg, member of the HQCJ. Good afternoon. With the decision of the HQCJ of Ukraine dated June 3rd of 2025, there was a non-competition for filling in 23 vacant positions of the High Anti-Corruption Court and Appellate Chamber of the Hague. Within the framework of this deadline, Zaitsev Oleksii Volodymyrovych submitted his application and admission to this competition for filling in the vacant position of the judge. As a person who complies with requirements of paragraph 2 of clause 2 of Article 7 of the Law on Hague, and with respect to conduct of qualification of vocation to confirm his capacity to administer judges in this court. With the decision of the QCJ dated September 16 of 2025, Zaitsev was admitted to qualification evaluation and participation in the competition. With the division of the HQCJ dated September 19 of 2025, there was appointed qualification evaluation within the framework of competition for position of judges of the Hague and the Chamber of the Hague. With the decision of the QCJ dated September 19 of 2025, there was appointed the qualification exam. It will determine its stages. With the decision of the QCJ dated February 4th of 2026, there was adopted the general results of the first stage of the qualification exam, according to which the candidate got 358.56 points and was admitted to the second stage of the qualification evaluation, that is, study of the dossier and conduct of the interview. Qualification of the candidate: in 2002, Zaitsev graduated from National Law Academy of Yaroslav Mudry and obtained full higher legal education under the specialty of legal sciences and obtained the qualification of the law. He has the academic title of PhD in law on criminal law and criminology, and he has a current title of associate professor granted by the Commission on January 25th of 2013. In 2002, the candidate worked at the position of investigator in Kherson region. In 2003 to 2004, he worked at the position of the investigator at the SSSU Directorate in Kharkiv region. In 2004 to 2007, he worked at the positions of senior legal counsel, lecturer, senior research fellow of Educational and Research Laboratory of the Institute for SSU Counsel Training within the framework of Yaroslav Mudry National Law Academy. In 2007-2008, he worked at the position of the director of LLC Center for Analytical Research, Yukon, and at the position of the Associate Professor of Political Science and History of National Aerospace University of Zhukovsky in Kharkiv Aviation Institute. Since 2008, he has worked in National Law University of Yaroslav Mudry. During this period of time, the candidate held different positions: intern, assistant lecturer of criminal law, associate professor of criminal law, deputy dean of the Faculty of Justice, deputy dean of the Faculty of Justice. Besides, in 2009 to 2011, he worked as a private notary of Kharkiv Notary District. He has the attorney's license. The attorney's license was suspended based on his application dated March 14 of 2013 due to incompatibility. Zaitsev Oleksii Volodymyrovych has fluency in Ukrainian of the second degree. He complied with requirements regarding advanced training of academic employees. The candidate submitted the Declaration of Family Ties, the Integrated Declaration, and the Declaration of the person authorized to perform functions of the state and local self-governance. During the competition, the Commission sent to the HGAs, SSU, OPG, State Border Guard Service, NACP, National Police, NABU, Ministry of Justice, and other public authorities, and we got respective responses. Also, I would like to point out that Zaitsev Oleksii takes part in the competition for the position of the judge of the Court of Appeal, pursuant to results of the first stage. He was admitted as confirming his capacity to administer justice in the General Court of Appeal, and he got 717 points. But in the ranking for the position of the judge for the Carpathia Court of Appeal, he did not pass because he was not the winner. Thank you. That's it. Have I mentioned everything correctly, Mr. Oleksii? Yes, everything is correct. Thank you. So I'm passing the floor to the chair. Thank you. Basic information has been voiced about the candidate. Mr. Robert, the floor is yours.
Thank you, Mr. Chair. Good afternoon. My name is Robert Broekhuizen, and I'm also the rapporteur of the PCIE. And we have looked, of course, in detail into the information we have received about you. And we have seen that your finances are quite difficult to understand, I must say, because I've seen that you have been using in the past something like 22 banks, where you had different kinds of bank accounts. You deposited money in those banks, and sometimes you withdrew the money and you put it in another bank account. And to, let's say, reconstruct what happened there is, I must say, very complex. And among the documents we also found, I don't know whether this is a decision, but I think it's a decision of the High Qualification Commission of Judges of 16 October 2025. Are you aware of this decision? Yes. And that's a decision that concerns the result of a special inspection with you. And I understand from this decision, which is a very long and detailed reasoned decision, that it was found, and I understand it's only some people who found it in the HQCJ, I don't know, that the commission that was dealing with this of the HQCJ found that the commission has not received convincing evidence that would confirm the legality of the origin of the funds used to place the deposit. And that's, I guess, about those 22 accounts with the money coming in and coming out. We have asked you questions, and you have provided us with an enormous amount of information, 450 pages, I believe, a few days ago. And also in the answers is referred to communication you had with the HQCJ, which we don't have. And thinking about that, we considered it would be best that you maybe explain first what you think is correct or not correct regarding this very long, detailed decision of the HQCJ, and that we first ask the HQCJ to do the questioning after that we do that, because clearly there's more knowledge on the other side than on this side. Is that okay with you that we do it that way? Yes? Is that okay with you as well on the other side? Mr. Chair, Mr. Cody used to do it this way? Yes? Okay. So maybe first that you explain that you explain us what you think is right or wrong on this decision of 16 October 2025. And not too long, please, because then because it's more than 20 pages in a concise manner.
Дякую за надану
Thank you.
можливість
Thank you
пояснити.
for this opportunity to explain. The matter is that in the decision dated October 16 of 2025, it is said that I have not provided sufficient documents that would confirm that I had the opportunity to open the deposit account with Delta Bank. After looking through this decision, in November of 2025, I sent numerous requests to different public authorities, banks, and I received responses in response to my requests, and that was happening until the 10th of February of 2026. So my last response that I got was dated February 10th, and on February 11th, I sent the response to the PCAE. I'm sorry, I will interrupt you. Please, we are limited in time, so please give answers to asked questions. We did not ask you about it, and Mr. Robert did not ask you where and when you were sending requests. Please, be concise. As of October 16 of 2025, the Commission did not have the package of documents that I have provided now to the PCIe and HQCJ. This package is significantly different from the previous one, and it confirms with documents that I had income during the period from 2002 until December 23rd of 2013. That's why information that was stipulated in the decision dated October 16 was based on those documents that I had available back then. Within 3 months after the publication of this decision on the website of the HQCJ, I conducted measures in order to confirm legality of income and the existence of the opportunity to have these banking operations as a self-employed person and as a service member starting from 2002.
Mr. Cody, floor is yours.
Так, Микола Олексійович, ми
Okay.
бачили всю вашу переписку.
We've seen your entire correspondence with the PCAE. Of course, we studied the table
Зробили для того, щоб
that you prepared in order to show your income.
зрозуміло, що
And of course, it's clear that
з'явилися нові документи, їх треба
new documents were received. We need to analyze them. We analyze them. And basically, the question
яким чином ви
of how you accumulated these funds to open the initial deposits that we were discussing. I think it was 2013, 2014. Yes, December 23rd of 2013. Yes. Okay, yes. So allegedly, it seems that you had enough funds according to the information that you provided. Basically, we can say that it was supposed to be enough for you. But again, I would like to point out that as of the moment of considering that issue on October 16 of 2025, these documents were not available, and the explanations that you were providing back then were not enough for us to reach another conclusion. That's it. Thank you, Mr. Robert.
Okay, now I understand. But we are in agreement that documents now show that at that moment, when the account was opened, there were sufficient funds. Yes? Can you please explain why you have 22 bank accounts, or had 22 bank accounts with separate deposits, and why you were opening the one and closing the other, and what was the idea of all of this?
The idea of all of these banking operations related to deposit was to gain financial profit. In different banking institutions, depending on some campaigns, promotion campaigns, they had different interests. for the lump sum of the deposit. Back then, they ranged from 18% to 30% per year in the national currency and approximately from 10 to 14% in foreign currency. Accordingly, taking into account information about these campaigns, promotion campaigns of banking institutions, I was using this financial tool to accumulate savings because it was honest, transparent, and it allowed me to feel confident about tomorrow.
And I understand that the idea was that you earned money with having those accounts by having interest. Is that the idea? Can you explain to me how much interest you earned on those accounts? Those 22 accounts over the years? Is that doable?
Так, мені відомо, це
Yes,
зазначено.
I know that. That is given in the table that I've sent in my response to the questions of the PCIe. And
В графі
in line additional income not subject to taxation,
треба рахувати без калькулятора.
I need to calculate. Without a calculator, I cannot tell you, but starting from 2005 until 23rd of December of 2013, approximately in foreign currency, it was
$15,000.
$15,000, and in the national currency, much more, because the interest was higher. I don't want just to delay time, but I would need a calculator. That is the line additional income in the table. I think it exceeds 200,000 hryvnias for sure. In order to simplify maybe the understanding of the flow of funds, not as an additional document, but just as an explanation, I would kindly ask you to draw attention, if you allow. These are not additional documents, they're just a scheme for flow of funds, based on my previous explanations. But we do not have it. I just prepared it yesterday. That's not a document. That's just a scheme for understanding. It looks not nice, a scheme for a candidate for position of the judge of the heart. No, that's just to simplify understanding of the flow of funds. Yes, I mean the classic scheme, which flow of funds chart. Yes. I would like to remind you provision of the rule ROP. Yes, we can attach new documents if, first of all, you submit a motion regarding that, and secondly, it will be justified. So you need to provide a motivation why you could not provide this documents earlier. So I would like to suggest to you to take into account this provision of the ROP again, and then we can consider it. So if you are submitting the motion, please clearly say that I'm submitting a motion on providing additional documents that I have not provided before. Then maybe we'll ask some follow-up questions to you, and then we will consider this motion. Or maybe you are not submitting this motion, and we will continue the interview. If necessary for additional explanation, I'm ready to provide this scheme. It's clear, but you need to decide for yourself. Do you suggest to us to get it or no? That's your initiative. Yes, I suggest that. You are taking part in the competition. You have to convince us about your integrity and compliance with requirements of the law of the Anti-Corruption Court. That's why, if you believe that it is necessary to provide this scheme or chart that you are saying, so please submit this motion, and then we will decide whether we need it or no. Yes, I'm asking Commission members and the PCA members to consider this in order to simplify the movement of funds on those accounts. And partially that explains the cause as well, because income under these deposits changed. So please consider this motion. If you do not need that, then I will understand the rejection. Okay, thank you. Dear members of the PCA, maybe in connection with this motion, you have some questions to the candidate. Then please, the floor is yours.
Oh, well, of course, the question is why he did not submit, or you didn't submit it earlier, so that because it would make it more understandable for us what all happened. And of course, you knew in advance that this would be an issue because there is this issue, and we have all those bank accounts. And I'm not a bookkeeper, neither an accountant nor a bank, so it's not so easy to understand. On the other hand, I would like to understand indeed what you have been doing. So in this respect, I would like to have it, dear chair.
Ну, напевно, що
Probably,
дайте відповідь. Бо я думаю, що комісія аналогічна.
I think that commission members have the same question. Why you didn't provide this before? Why didn't you submit it earlier? I have finalized preparing the answer on February 11th of 2026. And the production of this scheme just did not was not possible on time. At the same time, this scheme is not an additional document. It's just a visual explanation of the information that really contains lots of figures and dates.
Добре.
Okay.
Але ці питання обговорювали.
But these questions were discussed with you during the conduct of the interview with respect to your financial situation back in autumn of 2025. And obviously, you could have anticipated the discussion of these issues now during this interview as well. Probably, you could have prepared that in advance.
Невеличка ремарка. В розумінні
A small comment.
162 пункту нашого регламенту.
Clause 162 of our OP, the purpose of the provision of respective additional materials is establishment of circumstances that might significantly impact decision making. Largely speaking, the scheme indeed is not a material that can significantly change something. That's just visualization of what was provided to the Commission already. And maybe it is not even subject to those instances that are envisioned by Clause 162, because that's really not an independent material. It's just a simplification of perception of those data that remain unchanged until as of now. And I still believe that we can refrain from voting and just to provide it to Commission members and PCM members if it does not include any additional information or corrected information. It's just visualization, just like we are providing visualizations on monitors, etc., just for perception, for comprehension. So submission of the candidate of this information in this format. Okay. But yes, we can discuss that as to how we assess this information during discussion and decision-making regarding this motion. Do we have any other questions to the candidate?
Will you be able to provide to us explanations without this chart? Highly likely that for the audience to get understanding, to simplify understanding, this chart will require only 3 minutes for everyone to understand how information corresponds and how my replies are provided to the PCE Commission members. Then I suggest to have a closed deliberations in terms of satisfaction or dissatisfaction of this motion. Okay, then.
One second. I believe that my colleague Jessica would like to ask a question.
Of course.
I will ask just a simple question. You mentioned that for you, even as the person who has the primary knowledge of this information, you require a calculator in order to be able to understand it and explain it to us. Why should we be able to have a different situation than you, that somehow we also do not have a calculator? We have a rule requiring 3 days advance. Why are you expecting the PCIe and the HQCJ as the ones who are receiving this information? Why should we be expected to have a different consideration than you give only to yourself as well?
Я перепрошую
Sorry. for this discomforting, uncomfortable situation that has happened, it's related to the timeline which I faced, and only because of it. It's just to underline again, it's not new information, it's visualization of information which has already been provided, including to confirm my compliance with requirements to candidates. It's only because of the deficit of time. I'm sorry. I understand how your job is difficult, but from the objective perspective, I was just incapable. I just didn't have enough time.
Добре, немає інших питань.
Okay. Are there any other questions? Then let's move to the close deliberations of this motion and decision on that matter. So please wait for us in the hall.
І повідомте, будь ласка, коли
And please
припиниться трансляція.
inform us when the
Ми повернулись до
we are back
відкритої частини засідання.
to the open part of the session. We have discussed your motion, and
Одним голосом проти.
there is one vote against, all others are in favor. Your motion is satisfied. We will accept your relevant documents. Please give them to the secretary of the session.
У вас там дві копії, да? Ну,
You have two copies, yeah?
вони
Are they
ідентичні.
identical? Identical.
Ну,
Okay.
Дайте, будь
One
ласка, Роберту.
to me and one for Mr. Robert.
Там цифри.
These are just figures. Yeah. As you've mentioned, yeah, it will be 3 minutes for us, enough to understand.
Well, as my knowledge of Ukrainian is not so large, I don't. Okay, let's continue, Mr. Chair. Jessica will study the document now. The first question I have further, what I understand is that the money you had, yes, in 2005, part of this money is a result of the sale of an apartment. That's correct, right?
Абсолютно вірно.
Yeah, absolutely right.
And if I'm well informed, it went as follows: that you had you obtained the right to use this apartment on the 15th March of 2005, and then a few months on the 21st of November 2005, the apartment was privatized, and then 9 days later you sold it. Is that correct? That seems to be a bit strange to me that at first you receive in the same month or a few months the right to use it, you privatize it, and you sell it. Can you explain to us or to me as foreigner how this worked and that this was the proper way of doing this?
Станом на
As of
березень 2005 року
March 2005, as a lecturer of the faculty, I was registered in the housing list to get accommodation for permanent usage. When I was serving the military duty. In March 2005, despite of the fact that the housing list was related to the city of Kharkiv, the apartments for service persons were assigned in the Kharkiv region, in the village of urban type Pisachin. When I received a housing order and visited that apartment, I immediately realized that timing which I would need to commute from that apartment to work and back would require 3 hours roughly. For me, it was unacceptable. It was uncomfortable, and almost immediately I decided that I am going to sell this apartment, to privatize and then sell. At that moment, there was a provision of the social status of service persons and their family members in force, and also there was a law on on privatization of state property or housing, I don't remember the correct name. So I submitted relevant documents to the public institution. I received ownership document and then sold that apartment in November 2005. Further, this money were used by me to deposit at bank institutions.
But that means that you, let's say, you received this apartment nearly for free with the idea to start living there for quite some time, and what you did is you just cashed out on it, which means that the government got less and you got a lot of profit. Was that the proper way of doing that?
Definitely appropriate way to do it, because each citizen of Ukraine has a right to state privatization of property according to relevant provision of legislation. The fact that I sold that apartment doesn't mean that my actions were illicit, because as a user and further owner of that apartment, the location of that apartment in the village of urban time didn't suit me. And because of this discomfort of usage it, and because of the need to go to work, I privatized it and then further sold it as it's mentioned in relevant documents. And the state needed to provide me with accommodation, and how I'm going to use it, that's my right. And I used that right. And that apartment was not given to me as official accommodation, but it was given to me as permanent accommodation. The status of that apartment, of that housing, has not changed. Only ownership right has changed.
I know nothing about this, of course, because I'm a foreigner. But it seems strange to me that you apply to obtain an apartment with the idea that you live there, and then within the month you sell it. But okay, we will see what the other side has to say about it. What I further understand is that part of the money that you used in 2005 was money you obtained by acting as a notary. I believe it was $70,000 or something. Is it not true? Yes, mainly notary activities. You earned a lot of money as being a notary. And I was wondering, because you were still quite young, how did you were able to earn so much money as being a notary, and why did you stop being a notary? Because it seems to be very profitable.
According to submitted property declarations to the tax authorities for the period from 2009 to 2011. I declared 502,779 hryvnia, which were received from the private notary activities. Except of all the expenses, the net profit was 284,408 hryvnia. It's all confirmed and corroborated by property declarations, by receipts, and also information.
How did you earn it? I've seen that you have received $70,000 in the period 2009-2011 by notarial activities. And the question is, how did you earn $70,000? Because I don't have any document specifying how you were able to get this money, because this seemed to be, at that period of time, quite a lot of money, and you were quite a young boy. It's a long time ago. Oh, a young man.
Yeah, actually, for private notary, that's not significant profit at all in Ukraine. The notary's profit is actually generated based on the carrying out certain notary actions. It's done upon agreed price, but it should not be less than the defined state fee and as envisaged by the government decision. So all profits that I've earned as a notary, just trust me, it was much lower than my colleagues, peer colleagues, because I was a young notary, as you're rightly saying. As a notary, for example, if I notarize the agreement, it's a deed with immovable property, then the payment for such notary action should be not less than 1% from the value of this property.
So what you say is it is just ordinary, normal earnings for a notary. So, but why did you stop being a notary then? Because it seems to be quite profitable.
If we look at the dynamics of my income, which you can see at the table, the notary's income depends on the clients. So the parties could come to the notary for some action. So the notary could carry out thousands of different notary actions, but the value, the price received for those notary actions will be much less than only another one notary action. And you can see that the income has reduced later. But at the beginning of June 2011, I have received a proposal from the officials of the university to take an administrative role of the deputy dean of the Institute for Training Staff of the Prosecutor's Authorities in Ukraine. So, for me, those persons had huge authority. That was also about their trust to me as a lecturer at that faculty, and also it was about the challenge for me, because that institute was one of the key structural units in that system. So for me, it was like a sign of trust to me, and with that trust, I should also confirm or not. At that moment, I had already some bank deposit money, and it allowed me to feel comfortable, confident, and my goal was never to become a millionaire, to live comfortably.
What would be your salary as working in a university when you started after being a notary per year? How much?
My salary per year. For example, in 2012, it was 150,000 hryvnia. It's more than my notary income for 2011. It was roughly $2,000 per month. It was enough.
Okay. Regarding the notary activities, we don't have any underlying documents except that you declared it. So it's difficult to check it. And then I believe that, let me see. Well, at a certain moment you have all this money You put it in the bank accounts, all those banks, and at a certain moment the bank goes bankrupt and you're not able to withdraw your money from that bank. And you lose quite a lot of money. Huh? And the only thing you're left is with the claim on this bank, which you still have. And what I then see is that at present, you declare no bank accounts and only cash money. If I'm not wrong. And am I right to understand that this cash money means that you at home have money, not in the bank? Or do you mean with cash money, a bank account where the money is in? I don't know that.
Після 2015
After
року,
2015, starting 2nd August 2015, the tax on passive income was introduced on interest received from deposit agreement. So it means at certain stage, it just became non-beneficial from the financial perspective. That's first thing. Secondly, after the start of the full-scale invasion, I don't use this financial tool in order to avoid risks. All funds that I have in my family, we have it in cash. So I don't have deposit accounts, but I have only bank accounts, current bank accounts, no deposit.
What I find so special about it, what I understand is that you used to have all your money in banks that later were liquidated because of issues with those banks, money laundering issues, criminal liabilities, all kinds of issues. And your money was with those banks. And then those banks were liquidated, you withdraw your money, and now you don't have any bank anymore, it's in your pocket. And still, therefore, we cannot check or control how much money indeed is left. And that means that, yeah, I have schedule, but I have no clue how much money you have. The only thing I know is that what you tell me, which of course will be true, but I'm here also to check it. Okay.
Пане Роберте, дозвольте.
Mr. Robert, if I may comment. Regarding notary income, you mentioned that I didn't provide any documents, but I provided documents including property declarations which were submitted to the tax authorities, and there was also a reply from the main directorate of the tax inspection regarding they have received my income declaration as a notary from carrying out my notary activities.
I know. Let me see. At a certain moment, you had the position of a lawyer and a notary at the same time. Right? 2 licenses. And you had a license as a notary and one as an attorney. Is this normal practice? I think we have had something like this before, but was this allowed?
Щодо дотримання вимог
With
частини
respect to compliance with requirements of Part 2 of Article 2 on the bar. And by the way, that's also mentioned in the decision of the HQCJ dated October 16 of 2025. I really received the attorney's license in April of 2008. I engaged in notarial activities starting from September 7 until June 25th of 2011. Back then, the key principles of the bar's activities were set out by the law on the bar dated December 19 of 1992. At the same time, firstly, I obtained the license for the exercise of the respective project while working as the director of the research center. At the same time, that project could not be implemented financially. We were talking about the protection of interests of notaries in criminal proceedings. And then I switched in an interesting idea of obtaining the right to engage in notary's activities. At the same time, as a person who had the license, I have never conducted any attorney's activities. I was not registered with tax bodies and pension bodies as an attorney. I was only registered there as a self-employed person, a private notary. In law firms, attorneys associations, I've never been a member of them. Back then, the law did not envision the legal mechanism for the suspension of the attorney's license. The High Qualification Commission of the Bar admitted in its application that in connection with the then current legislation, the legislation did not contain the suspension of activities, and termination of activities could be applied only as a disciplinary sanction. So the law that existed back then contained limitations, but ways of their removal for people who had the status of the attorney and want to engage in other incompatible type of activity was not envisioned by the law. I would like to draw attention to the fact that the current law on the bar and attorney's activities, which came into effect in August of 2012, directly stipulates that it is prohibited to combine the obligation to suspend the attorney's license and the proper procedure for its implementation. I suspended my private notary's activities on June 25th of 2011. This way, as of August 15, that is of the date when the current law on the bar and attorney's activities came into effect, circumstances of incompatibility were absent, and I submitted an application as a faculty member. I would like to draw attention of members of the PCIe and members of the HQCJ to the fact that similar instances have been repeatedly considered by the HQCJ in 2024 and 2025. That was about the existence or absence of the violation of incompatibility principle with respect to persons who had the attorney's license and were appointed to the position of the judge, but did not suspend their license. In none of the 6 decisions adopted by the second chamber, the panel and the plenary session did not establish any violations. Also, this issue was assessed by the High Council of Justice, which also in 4 of its decisions, starting from November of 2023, Mr. Oleksii, I would suggest to you to be more concise in answering the questions asked about you personally. I think that's not really the format of the interview. Probably we do not want to hear that when you are talking about the analysis of the decisions of the HCJ, but they were not about you personally. Some prejudication facts, even if we could apply this institute. We are limited in time, so I would suggest to you to focus more attention on the information that concerns you specifically. Thank you.
Can you tell me where you lived after you sold your apartment in 2005? Where did you live?
Я проживав в місті Харків.
I lived in the city of Kharkiv. In the city center, I was renting an apartment, a room in the city center of Kharkiv.
You didn't live with your parents. You lived by yourself in a room in the city of Kharkiv.
Мої батьки проживали.
My parents lived until 2023, 2022 in Kherson region. And I lived starting from June of 2003 in Kharkiv.
In a one-room apartment.
Я орендував одну. Орендував.
No. I was renting only one room in a 3-room apartment.
Власниця квартири, яка здавала.
There was the owner of the apartment who was renting out a room per apartment.
You didn't live in the apartment you were given by your mother in 2010?
Ні, так ми кажемо про 2005.
No, but we are talking about 2005, when I sold the apartment.
Переїхав до квартири.
I moved.
Пізніше, звичайно, я проживав, коли ми...
You moved in 2000.
Later on,
Okay.
yes, of course, yes. That's confirmed by passport data, yes.
Okay, and I understand that your sister bought an apartment in 2025. Do you know that?
Мені це невідомо. Я
I
знаю,
do not know about that. I know that she became the owner of a one-room apartment in 2025.
Yes, and what I was told is that your sister did not have any income between 2022 and 2025. Did you lend her money?
Ні, я не позичав гроші.
No, I did not lend her money to buy the apartment because it was bought by her back according to the materials of the special check. The transaction was concluded in 2020 with deferred payment until 2022. She had income during the period from 1999 until 2022, in particular as an individual entrepreneur.
Well, for this time, I'm finished with my questioning. I'm looking at my colleagues. No. Norman, Jessica, Mary, sorry. No? Over to you, Mr. Chair.
Окей. Перше, Олексій Володимировичу, з ваших пояснень я зрозумів, що...
Now, from your explanations, I understand that you disagree with the decision of the SQCJ dated October 16 of 2025. Did you challenge it? Dear Mr. Oleg and members of the fourth panel, I respect the decision of the HQCJ and I did not challenge it. My counter argument provided now in writing is only the illustration of my fight during the competition, as we were told by a demonstration of emotional resistance, etc. Okay. Sorry, I would like to clarify in order to avoid, as we were told by HQCG member during meeting. What do you mean? Those meetings that were organized by Mr. Sergei Chumak, they were telling us that competition you have to convince Mr. Sergei. I mean YouTube meetings in February of 2025. You are talking about the work of the commission regarding popularization of the competition, right? No, that was already the explanatory work with the candidates about the stages of the competition to the Court of Appeal. To the Court of Appeal, yes. Okay, sorry, maybe I did not mention. Just for understanding, in the competition for the appellate instance, I will explain for the public. The commission, including Mr. Sergei, as just like other members of the commission, were recording videos with explanations. Sometimes these were live broadcast videos, and we were answering some topical questions that the competition participants were concerned about, just for us to understand. I would like to clarify for the context, because it is such an impression that there was some consultation. No, that was a YouTube channel. The commission was doing that for all the candidates who successfully passed the qualification exam. As far as I remember, I, as the head of the working group on the appellate instance, indeed had an hour or 2 hours with explanations of how the stage of the dossier examination and conduct of the interview would take place. But that was a general meeting for all the candidates. Thank you, Sergei, for this information. for assessment of the compliance of the candidate. Yes, but that was within the framework of the competition to the appellate instance. Yes, I would like to follow up information about the appointment. It was not an official appointment, right? What were the grounds? In that year, it was issued for permanent use, yes? Yes. You were in the line of persons in need of improvement of housing conditions, or was it some official line? No, I was in the line as a citizen who required housing. And according to documents I provided, I even have a picture of the order that this is not an official housing. Yes, and the decision of Pisachynska Village Council was about that. Very briefly. So you received the housing premises by local self-governance body, right? Yes. By village council. Village council. Okay. Did you live there? Where you registered that? No, no. That's the peculiarity that I was trying to explain. I was in the apartment line together with other service members of the institute in Kharkiv. Back then, in the city of Kharkiv, the Security Service of Ukraine could not provide us with housing for permanent use. But it was suggested that as an alternative option, either you agree to take it in the village, that is at the distance of 15 kilometers from Kharkiv, or you are not getting in the foreseeable future anything. Okay, understood. Thank you. Yes. Good afternoon, Milan, Commission member. Tell me, please. So it was permanent use housing, and you received it following the order as a person in need of improvement of housing conditions, in particular the place of service. Yes, absolutely right. Tell me, please, then, and how long you were in the line before then? Starting from June of 2003, I was transferred from Kherson to Kharkiv, and I registered starting from 2003. And in which year did you get the appointment? In March of 2005. So in a year and a half, you were in the line to get this housing. That line was not provided with housing. All 5 persons mentioned in the decision of the village council were waiting for a potential opportunity to get housing, and they could not provide us with this housing in Kharkiv, but an alternative option was suggested, Kharkiv district. But you remained in the line? No, of course, it was fully extinguished. Yeah, but that's not Kharkiv, that's Pisochin, that's Kharkiv district. And wait, what was your military rank when you got the apartment? In March of 2005, I was a senior justice lieutenant. Thank you. Let's continue then. We received information from civil society organizations, and some of it has already been addressed by you in your correspondence with the PCIe and in response to our request, but I would like to ask some of these questions to you now. In 2014, you published an academic article in Russian academic journal, official bulletin of St. Petersburg State University. And according to the information, the publication was received the article in 2013, correct? Please explain how it happened and when it happened. Yes, indeed. I prepared in 2013 this academic article that was dedicated to the memory of the professor of our faculty. I sent it to the official bulletin that you've just mentioned, to St. Petersburg, because during the Second World War, he was the head of the Faculty of Criminal Law. And I suggested to them to commemorate the memory of the professor who worked at 2 universities and it was accepted in December of 2013 and published. After temporary occupation by the Russian Federation of the Autonomous Republic of Crimea and separate regions of Donetsk and Luhansk regions, I had no personal or academic communication with citizens and representatives of the Russian Federation, and will never be. When was it published? In early 2014. That's even showed by number of the journal, number 2. I do not know. I don't have access to this journal. I remember for sure that it was accepted by the editorial board for publication in 2013 without any remarks. But with respect to further actions and my assessment of the state aggressor is expressed in my academic publications about collaboration activities and state treason. Now you cannot name the date. It's like beginning of 2014. In months, days. I think that based on the number of journal that was early February. Early February. I can only assume because I do not have the journal. You did not do anything to withdraw this publication. No, the mechanism of withdrawal of the published publication is not available. It's already published, and I can only stop any activity. I would like to draw attention of the Commission members that, for example, termination of the agreement on cooperation in the academic sphere was terminated by Ukraine in 2022. But I terminated all of my relationships with Russia in 2014. Okay, understood. On the 31st of January of 2022, the mother of your wife obtained ownership of a 2-room apartment in the city of Henichevsk. Based on the sale and purchase agreement, can you explain sources of origin of funds used to buy this apartment? At once, I would like to point out, just for you to understand me correctly, that my mother-in-law is not my family member in the understanding of the anti-corruption legislation. I only have the information that is available to me either from the dossier materials or from the words of my wife and her sister for whom it was bought. That apartment in Henichevsk was bought in early January of 2022 so that Yana, daughter, that is youngest sister of my wife, would live there, who got married in 2020. The source of origin of funds, according to this word and written statement, showed that these funds were personal funds of my mother-in-law, funds received by her from lease of land plots. Some of these agreements are available in the materials of the special check, as well as personal funds of the young family for whom it was bought. That is the information that is given in the statement of the young sister of my wife, whom I asked to explain it because I have no relation to that real estate object. And with respect to your simultaneous participation in 2 competitions, we have to clarify about your priorities, and please recall our interview that was held in October of 2025. What you were saying there. Probably you saw the appeal of the civil society organization. Yes, that was topical as of October 2025 because I was trying to win in the competition for filling in a vacant position of the Court of the Carpattia Court of Appeal. Since I did not achieve the objective in that competition, so the choice of the priority has been resolved on its own. Only one competition has remained topical for me because in the previous competition I lost.
Ми зараз інтерпретуємо те, що ви казали.
Can we interpret it in the right manner right now? That what you have presented to us at the previous interview, that you have submitted your application for the competition at the HCC only because you didn't understand the timeline of competition for the General Appellate Courts. No, it was just only one. The reason, the issue is that when on 9th of May 2025, the list of all candidates of the Zakarpattia Appellate Court was announced, I realized that this competition would be abnormal. What about that abnormality? You know, the competition, the number of participants in the competition is much higher than Kyiv Appellate Court's competition. Just answer yes or no. So you mentioned during that interview that for you the priority was General Appellate Court, Zakarpattia Appellate Court. If I won there, then according to the competition provisions, I would have stopped my participation here in this competition. And what about, so you have submitted your application in competition to the HCC just because you wanted to participate in another competition, because you do not know how will be the result of yours in that competition. We are trying to find out about your motivation. My motivation, I informed you at that session and I'm repeating it right now. Both competitions are related to my specialization, specifically my specialization in criminal law in particular. I didn't participate in competitions for judges of general, commercial, administrative specialization. That's why the competition procedures are based on my professional and academic interests. The fact that competitions were in parallel, for me, it was both, like a backup version for my efforts that I contributed on provision of documents, communication with the Commission members and CSOs are not in vain. I understood that I could lose or win, and that's why, for me, the alternative was to participate in the HC competition. And when I realized that I would not become a winner, I focused exclusively on this competition because it reflects my area of professional academic interests. Okay, clear. Then let's imagine the situation as it was last time. So we have not yet completed the competition to the HSC. The results of this competition are not yet known. The results of the special joint meeting are not yet known. The results of interviews with the panel or the chamber, I don't know with whom, are also not yet there. But you already have your competition for the General Appellate Court, yeah? So you have your results of tests and so on. So you can already compare your results with other candidates. So your scoring results are quite high. And for example, for the Zakarpattia court, there are certain vacant positions. Some candidates were just denied in offering their job. Or in another court near to your place of residence or close to your interests, there are some vacant positions. And they announce a new competition to that court. Are you going to apply to that competition? So, you see already that your scoring is quite high. It will guarantee that you will be at high ranking place. I've got your question. I will apply. So, taking into consideration the results of the current ongoing competitions, for me it's clear that the competition for appellate courts based on public information would end, would not end till the end of the cadence of this HTKJ composition. The HACC competition would end much quicker, would be completed much quicker. And so it means my chance to become a judge of the Zakarpattia Appellate Court is very, is not very plausible, is very abstract. Sorry, I didn't get your answer. You didn't provide us with an answer. So I'm focused as of 18th February 2026 exclusively at this competition in which I'm participating. That competition has already been finished for me. But if tomorrow, 19th February, there will be no tomorrow. But how do you know? But if tomorrow there will be an announcement, because I follow the news and the work. But everything could happen. Everything. So you don't want to dream, yeah? Yeah, I don't want. I'm a realistic and pragmatic person. Okay. Regarding all other things, concerns, and issues which were raised during our analysis of your dossier, I have no other questions. I will ask only one more question to clarify your competence to work at the HSC. So tell me, is it possible to apply special confiscation to property of which is under joint ownership of a couple if one of the owners is a perpetrator? And in which cases it's possible? Based on a legal conclusion of the joint chamber of the Cassation Criminal Court of the Supreme Court, which was published at the beginning of February 2026, special confiscation is allowed if one of the couple, one of the married couple, used this property, or if it became a tool or means of committing a criminal offense. That's a change in their legal position, and it's quite on the table right now in terms of different discussions. Your colleagues, Mr. Yaroslav, regarding practical things, practical questions, I have one question. What about limitation of liberty as a sanction? Who is not subjected to application of such a tool? So it's envisaged by the criminal code, and maybe I would be mistaken. I need to look at the criminal code. As far as I remember, limitation of liberty shall not be applied to service persons, to pregnant women, to women who have kids up to 7 years old, and maybe I'm mistaken. Sorry, maybe I don't remember everything by heart. But yeah, we need to look at the provisions of criminal code. As always, I would always open text of the legislation. So to a certain extent, it's related to practical task. So did you analyze your work? No, I have not looked through the work, through the task, so it's not present in my dossier. I was preparing a lot on my on other materials and things. Yeah, I understand that there is certain mistake is there because I have received less points that I expected. So I will analyze later. Yes, there are also other people with disabilities, sick persons, so on. So there are some things that you missed in your practical task. Okay, thank you. Your colleagues, as far as I understand, we have received an error rate alert. Yeah? So give us 30 seconds to clarify what's the reason. Ballistic threat? Dear colleagues, let's decide. So first, dear candidate, first of all, what's your opinion in such situation? Shall we continue our interview or not? Yeah, we shall continue. Okay, dear PCA members. So there are no other details apart of that's a threat. At least for now, I don't know anything about it. Maybe some of you knows more about it from other sources, but for now we don't have information about any specific hit. No, there is only a threat.
Let's go on.
Good, dear colleagues. What do you think? Shall we continue? Okay, let's continue and monitor relevant channels of communication. Okay. Dear colleagues, are there any other questions? I have a question regarding your motivation. I would like to to close this part because we didn't get your straight answer on that matter. During an interview, Oleg Leonidovich has already asked you about your motivation, and you have informed us that, yeah, anyway, right now, you are participating in this competition to the High Anti-Corruption Court because it's quicker. The procedure happens quicker. So what's about your motivation? Is it because you would like to become an HC judge because it's a quicker procedure of competition? Or what? Because you are choosing between different courts with absolutely different tasks, appellate court, HSCC, because again, your professional activities, very diverse. You were a service person and scholar and entrepreneur and notary, a judge. So there are so many dimensions. So where you focus? What's more rational? What's swifter or what? Thank you. I have never been an entrepreneur, so I didn't have such a status. Regarding the competition procedure, I'm straightly, clearly claiming and saying that for me, the decisive factor that's a professional interest in the area where I work. As of now, I participate in the ongoing competition to the High Anti-Corruption Court of Ukraine, which is even more related to my professional interest than the General Appellate Court, where, yes, indeed, as it was rightly mentioned, where I can receive a position of a judge in the civil chamber. Now, this competition, HC competition, is more corresponding to my interest, professional interest. It's not about swiftness. I don't participate in such competitions only to get some results, but no, in order to self-realize myself, to professionally contribute and be useful to the system to which I submit my documents for participation. Sorry, a small comment. Back in 2018, I also participated in the competition for the Cassation Criminal Court of the Supreme Court. I was the 14th, and there were only 13 vacant positions. So now, I am behind by 2 vacant positions. So I'm motivated. I want to show to the Competition Commission that I'm capable and I am eligible with the requirements for candidates for the HC judge's position. To follow up, the question of Madam Halina. So again, about swiftness or motivation. So right now you live in Kharkiv. No, in Lviv. In Lviv. So we are relocated persons in Lviv. Okay. Then question is cancelled. Are there any other questions? Dear PCIe members, are there any other questions from your side?
No? Mary and Norman on the screen. Questions? I don't think so, Mr. Chair.
Окей. Пане Олексію, вам надається можливість.
Mr. Oleksii, you have an opportunity to address the Commission, the PCIe members, with some additional comments, words, or needs. I don't have any additional information to provide. Everything they wanted to provide to you, I provided. Again, dear PCIe members, I'm sorry for this late delay with provision of this chart, and sorry to the Commission members that provided it only today. Okay, thank you. Thank you for your participation in this interview. Dear candidates, thank you. The interview is over.